Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Christopher Marchese, case number 25 AP 289. Appellant Christopher Marchese is self-represented and appearing by phone. Representing the appellee, the state of Vermont, is attorney Evan Meenan.
Okay, thank you very much. Good morning. Mr. Marchese, can you hear me?
Yes, I can hear you.
All right, we can hear you, sir. You understand you have 5 minutes. We'll give you a warning when you have a little bit of time left, and so please go ahead.
Wait, wasn't it 10 minutes? Why is it 5 now?
You have
Why
5
you putting me
minutes.
on my time?
You have 5 minutes, sir.
That's not what it says on the paperwork. It says 10 minutes will be granted to me and 10 to the other person.
You have 5 minutes, sir, so please go ahead.
I want them to go ahead first.
Do you have anything more to say?
What, is it in my right to hear them first?
All right. We'll turn to counsel for the appellee. Counsel, please start by introducing yourself, identify your client, and then proceed.
Good morning. May it please the court. My name is Evan Meenan, and I represent the state of Vermont, which in this case is respectfully asking the court to affirm appellant's convictions for 2 counts of criminal threatening against a public servant. This morning, I'm happy to answer any questions that the court has, but the state is satisfied with the arguments as articulated in its brief and doesn't have any further comments that it wishes to independently make. Thank you.
All right. Thank you. I don't see any hands, so we'll turn back to the appellant. How much time does the appellant have left?
Appellant has 4 minutes and 49 seconds remaining.
All right, Mr. Marchese, please go ahead.
So I said a motion of argument, which is not briefed at all. It's a motion of argument. It just got sent about 2 days firmly ago. Reciting the VRE 404, the VRE 403C, and reciting the 208, as well as the 14th and many other ones, such as 3166, the 23.2.A, as well as the 33.2 US 708, 721, 1948, as well as the the 13th chapter under 249 hate crime, as well the following, which would be Act of 1971, 42 U.S.C.S. 1983, deprivation under the color of law in general by government official, Chapter 7 under 702 constitutionally, 704 habeas corpus distinguished, 705 recognition with other statutes, as well as many others, such as jurisdiction, and 242 jurisdiction, 305, 111, 133 particular proceedings, 1592 forfeiture to servitude or for labor, as well as violation to the 13th constitutional right, 1589 as 1583 enticement into slavery, 1039 false statement, 201 bribery public official, chapter 211 venue jurisdictions, venue 320, 3231 district of court, 3232 district of offense relief, 3234 change of venue and other district, meaning with consult and consent of parties, as well as I have submitted many citations upon chapter number 10 of Declaration of Rights under Common Law by enforcement as prosecution, chapter 65 under malicious prosecution. 10.13 excessive bail as no bail as 1014 criminal unusual punishment, many of them actually under the federal constitutional right, as well as unlawful representation of counsel under the 4th and the 5th and the 8th constitutional right, on which many of these things during trial, including the not having me present, which is a constitutional federal right that I have, to be in court while switch of venue of any attorney or withdraw the attorney, and due to the several appearances in court without my presence, just to take advantage of enticement into slavery modern era, which is
Appellant has 1 minute remaining.
and including the fact of having a different district attorney, Mr. Thomas Paul, run the session on which he committed a violation to the VRE by discriminating against my past and having his family member, Thomas A. Sinai, and then Thomas Enzer be representing me, caused the unlawful representation of counsel and a mistrial by having Mr. Christopher Gould state that I was going to kill the judge, the district attorney, and the attorney. That is a complete conflict of interest and a mistrial besides jury people that have businesses, including a hotel owner named Jack Johnson, that was there that day influencing these people to actually find me guilty, which upon the victim being so stating that I did not threat her directly and my threats were not directly intended to her, was a separate third-party argumentation that did not have nothing
Appellant
to
has
do.
no time remaining.
Okay, your time has expired, Mr. Marchese.